Good morning and welcome to the webinar on South Dakota's new data breach reporting law. I'm Katie Sieverding, Government Relations Coordinator for the South Dakota Retailers Association. First, I'm going to start off with a little information about our association. SDRA is a 3,900 member statewide association, and we represent retailers in the legislative and regulatory process. We also provide information, offer trainings for food service and alcohol licensees, and provide member services. Those include credit card processing, business insurance, and data security. In addition, we have an agreement with a labor law firm that allows our members to get answers to employment law questions from an attorney. Today's webinar will feature a presentation by Jody Gillaspie. Jody began her duties as Director for the Office of the South Dakota Attorney General, Division of Consumer Protection in 2012. Prior to that, she was an investigator with the division and has been with the Attorney General's office for over 20 years. The division's role is to pursue unfair and deceptive trade practices that affect SD consumers on a daily basis. Before we start, we have a note-taking version of the PowerPoint that can be printed from the handouts area on the side of your screen. The phones of all of the attendees are muted, so we won't be hearing any background noises. We'll have a question and answer period at the conclusion of the presentation. If you'd like to ask a question, just go to the panel on the side of your screen. There's an orange arrow at the top you may need to click to maximize that panel. You type your message into the box and then click on send. At the conclusion, I'll read the questions out loud and Jody will provide the answers. I'll now turn it over to you, Jody.
Thanks, Katie. Like she said, my name is Jody Gillaspie. I am the Director for Consumer Protection. We are a division within the Attorney General's office, and we deal with deceptive trade practice violations that basically anything that can be construed as a deceptive act towards a consumer typically falls underneath our umbrella. Today we're here to talk about what the new data breach law state and how it affects businesses and consumers alike. That goes into effect July 1st. I'm going to give my disclaimer that one, I am not an attorney and this cannot be construed as legal advice. It's simply to go over what the statute says and give you a broad or brief overview of those statutes. So we'll go ahead and begin with that, and then I believe we're going to have a Q&A at the end for anybody to ask questions. First thing that you need to do is basically, one, determine if you have a breach within your system. How do you do that? Your next steps, your next steps would be to tell you what a breach of a system is. It is basically an unauthorized acquisition of unencrypted computerized information. I'm not a computer tech person by any means, but you also need to know that if there were encrypted computerized data and an encryption key was also taken, that would be construed as a breach of a system as well. Next, you need to determine what was taken. Was there personal information taken? First and foremost, they have to have the first name or a first initial and the last name in conjunction with a combination of the following elements. Could be a social security number, a driver's license number, health information, an account, a credit card, debit card, combination with those security codes. It also would include an identification number that an employee gives their employees. Again, in combination with an access code, a password, the biometric data that's generated, the analysis of a human body characteristics, anything that is unique to that person. That would be considered, again, personal information that is kept in a computer system. Next, there is also what we call protected information. Was that information that was taken, such as a username or an email address, in combination with that password or security question or any other information that permits access to that online account. Again, an account number or credit card number, again with those passwords or combination of those questions. That is considered protected information. And the statute lays that out. The statute will reside in SDCL 22-40, and those definitions can be found there as well. It goes into a little bit further depth there that you can look at. Next, once you make those determinations, the other thing that I need to point out is that the protected information does not include a person's name. So you need to be aware of that. The next is, yes, you've determined that information was taken. What are your next steps as a business? The notifications that have to be given is once that notification, or you notice that there is a breach, within 60 days from that notice of the breach, you have to disclose to any affected parties. Then if it is going to be over 250 people that are affected by that breach, a notice also must be given to the Attorney General's office. There are notification delays if law enforcement gets involved and they deem that a notification would hinder or impede a criminal investigation. That will delay that notification. Once law enforcement determines that, or they give you clearance to send out those notifications, you will have 30 days from the time that clearance is given to send out those notifications. So, what kind of notice to the residents will satisfy the statute? A written notice or an electronic notice. An example of an electronic notice would be that you, a consumer, or you have a business that has a website and a consumer opts not to receive your electronic notices. That notification of a breach, you would not be able to use electronic means to notify that person because it's not permitted because they did not give you authorization. So you need to be aware of that. The other would be a substitute notice if a holder, information holder, demonstrates that the cost to provide that notice would exceed $250,000. A substitute notice may be used and could consist of an email notice, a conspicuous posting on your website, or a notification through statewide media, the newspapers, radio, those types of things. Equifax, when they had their data breach, used the conspicuous posting. They used the statewide notification media sites. They also sent out notices to consumers that had additional or multiple personal identification information stolen, plus protected information. They did send notices out to them. So those are some of the things that they used to get the word out to consumers. So the next part of the statute talks about yes and no. We had a breach, but the business determined that no harm would actually come to the affected person based off of the information that was taken within the breach. So what are your next steps if that determination is made? It would be a notice of that findings must come to the Attorney General's office. And it must show the documentation of how it was determined that no harm will come to the consumers. You must maintain that information at your place of business for no less than 3 years. That's so that it can, if you were to have a data breach here in August and 6 months later you had another breach, but again you were determining that no harm came to any of the consumers, we would still want to be able to look at that to say something is going on because you've had a breach twice now within a 6-month period, and so we may need to look at that a little bit differently. So now you've got kind of the basics of what the statute says. So now what happens if you choose not to report a breach? Failure to not comply with the notice requirements is enforceable under the Attorney General's offices, under our deceptive trade practice statutes. basically for purposes of criminal and or civil action. And those fall underneath our deceptive trade practice violations are 37-24-6. The damages, the statute goes on to say damages of not more than $10,000 per day violation may be assessed. Failure to give you an example of a company that failed to report the data breach. You're all aware of Uber. They had their data breach. They did not notify anybody, had the data breach for a year. They chose to pay the scam artists that scammed their or breached their system, basically hush money to not notify or let the public know that there was a breach. They continued to do that, and eventually Uber made the notification to everybody. Their employees plus consumers that had paid with credit cards were affected by that. So there's some issues with Uber itself because they, again, did not report that breach. So this just gives you a broad overview of the statute, very brief, and we'll go into some of the things that we've noticed and some of the questions that going throughout the state that I've had asked. The common question or response that I receive is, well, I don't do anything on the computer. We don't keep any of that. And one of the things that we brought up was, okay, do you keep your employees' records and do you send out your payroll information through the computer system, or do you generate W-2s on a computer system? And they looked at us and they said, well, yeah. And we said, well, then you potentially could be affected by that because you are keeping that personal identifying information underneath on a computerized system. And so you need to look at this. And so that resonated with a lot of people in that respect. And a lot of people just don't realize that it does affect them. So that is one thing. I want to give you some examples of things that we have seen in the past that may or may not have been protected if we had this statute. One thing that we ran into here, and this has been several years ago, where we had a higher education facility that had cleaned out a storage room that had boxes of student records in there. And they inadvertently had thrown away about 7 boxes worth of documentation that had students that had graduated and have been long since gone, but they did dump those records. An individual watched them dump the records, and he went and picked up a couple boxes of them just to see what it was. At that time, it was paper documents. It wasn't a computerized documents or a floppy disk or anything like that. Could that, if we would have had this statute in place, would that have been something that would have been reportable? At this point, we would have had to determine if that information was copied from a computerized system. And then there may have been something further that we would have had to look at. Under this current statute, because it was a paper copy, it wouldn't have been something that would have been prosecutable under this current statute. So I just want to make you aware of that. This one where we've had the W-2s, we had a business that had contacted us and just simply said, we don't do anything on the computer. Everything is written, including our credit card receipts. And so they don't keep anything on a computer. It was all put in a file cabinet. Unfortunately, it was not a locked file cabinet, and somebody broke in and stole all of that information within that file cabinet. Again, that was documentation that was never placed on a computer, and it wasn't copied from a computer. It was simply generated in that handwritten person-to-person information. And so as the statute currently stands, there would not be anything for us to do at this point underneath the current statute. The other one that we get a lot of questions on is a business has all of their customer's credit card information stolen during a two-day period. Yeah, that's something that currently underneath the current statute that is reportable. If it's all through the computerized system, it would be reportable as a breach if they were able to obtain that consumer's first name or initial, last name, and their credit card information. That would be reportable at that point. And Katie, I think at this point, if there are other questions, we could open it up to that.
Okay, thank you, Jody. Again, just for everyone that is listening, if you want to ask a question, you go to the panel on the side of your screen, and if you don't see the panel, you'll have to click on that orange arrow to maximize it. We do have a few questions that have come in, so I will start with those. The first one, Jody, let's say a business contracts out some of the stuff that they do, so like their payroll or their human resources. Who is responsible then for notification if there is a breach? Whether it happens at the business level, we'll talk about that, and then also at that, whoever that third party is for their payroll or HR.
Sure. And again, I need to give that disclaimer that we cannot construe this as legal advice. I will tell you that that question has come up, and we bounced this around. And right now, the general consensus is that the business would be the responsible party simply because the consumer gave the business their personal identifying information. The business then gave it to that third party. And so the business is the one that has the onus to make the alert. If they deem that, the third party is responsible, then it's up to that business, as the current statute stands, that they would be responsible to go after them. The consumer, and the example would be, a consumer that gives a business a credit card, and that credit card or that third-party processor is the one that is hacked into. That consumer is not going to know who that third-party processor is. So if that processor deems that it's going to be, and they're putting their notification out because of the state that they are corporately headquartered in requires them to do that, and they deem that conspicuous notice on their website is good enough notification, our consumers are not going to know who that third party is. They're not going to know to look for that breach. And so we go back to, I didn't give my information to that third party, I gave it to the business directly. So they would have the onus in this at this point, we feel.
Okay, thank you. The next question, if we take a credit card for a payment, write the number down, the expiration date, code, all of that information, how long does that have to be kept?
That question, unfortunately, doesn't fall within this data breach information here, and I would simply refer that to the Department of Revenue, and they can be reached at 1-800-829-9188, or their 605-773-3311.
Okay, thank you. Speaking of different phone numbers and stuff, we have one question that says, do you have contact information, email, and phone number for your office so that
yeah, sorry about that. I didn't finish the slide. Sorry, Katie.
That's okay.
Yes, there's also a reference guide in there because part of the statute also goes on to say that a notification must be given to the credit bureaus, which are Equifax, Experian, and TransUnion. So they would need to be notified. So the reference guide here gives the actual mailing address and their phone number for individuals or businesses to contact. Our contact information is here. We do have the toll-free number, 800-300-1986, toll-free, in-state only. So it should be flipped around. Or we do have a helpline, consumerhelp@state.sd.us, if they've got questions that they would prefer to send in, they can certainly do that. This information will be loaded up to our website, which is consumer.sd.gov, so that they can review it and that others can look at.
Perfect. So if someone does experience a breach or what they think may be a breach, who specifically do they contact at your office? Is
At
it
our
the
office,
general number?
Yep, there is a general number, 605-773-3215 is the main Attorney General's office's number.
And that would be who they would contact?
They can contact that number, or they can contact Consumer Protection so that we've got notification and we'll place it here and within our system. And our direct number, again, that is at 800-300-1986
Okay.
or 605-773-4400. You know, in the past, we had a situation here, and it's been probably, this summer it's going on 2 years, where we had a business that unfortunately got one of the ransom emails, hijacking email to their whole system, which shut it down. And the business opted to pay the ransom. The hijackers unlocked their system. They, of course, had somebody come in and clean their system. And unfortunately, the next day, ironically or not so ironically, they also received the Microsoft scam call, in which the scam artist indicated, "This is Microsoft. We understand that you had a problem with your system, and we need to go in and just verify that everything was taken care of." Unfortunately, the person that answered the phone call obviously knew that they had a huge issue with their system the day before, and she thought that they were calling to check in. She inadvertently let them back into their system. Those scam artists stayed in their system for approximately 6 hours and obtained everything. All of the employee records, all of their banking information, plus they also obtained individuals that were paying their bills to the company, and it was other businesses that were affected because they were paying their bills to them. And so we helped them, you know, walk through the steps of what they need to do to make those notifications to the consumers, because it was huge and daunting to that company, and helped point them in directions of what they needed to do next. So, you know, if they've got questions, by all means, give us a call. If we don't know the answers, we're going to at least try to point you in the direction of where you need to go.
Great. So this kind of goes back to, I got a couple of questions here about the law itself. So if the only thing that was taken was a list of names from a computer, no other identifying information, what is that a breach? Is that considered a breach or not?
If just the first name and an initial and a last name were taken and nothing else in combination with like the social security number, where are the other three? Sorry. In there, I think I got them. Or driver's license, health information, account numbers, credit cards. If it was simply that first name and last name and nothing else, that would be a situation where they did have a breach of their system. Their system was compromised. Here's the information that was taken, a simple notification to the Attorney General's office that indicates that we had a breach on this particular day. There is no harm to the consumer, we don't feel. Here's what we found. And that's simply a notification sent to us so that it can stay on file. Again, you know, if we notice that in 6 months they had another breach, there's still something that they need to do within their system that they're not. So no notification would have to go out to the consumers itself, but a notification would still need to come to the Attorney General's office stating that a breach was, their system was compromised, so no harm came to any consumers.
Okay, and then what does the Attorney General's office do with that information, whether they deem a breach happened or not? Is there a news release that's issued by the AG's office?
Potentially there could be. depending on the severity of it. Not sure, we're in the early phases. I'm not sure if there's something that will be, put out on a website. Just not sure yet.
Okay, so yeah, I just got a kind of the same follow-up question then. So we don't, because it's so early, you don't necessarily know what the office is going to do with that information. I mean,
Right,
there obviously could be some prosecution or some legal ramifications, if there's violations and such, but the actual, let's just say that first name and last name was taken, nothing else was taken. The Attorney General's office deemed that no breach or no
further action is warranted.
Yeah. Then what happens? What do you do with that information?
Right. Hypothetically at this point, because I can't say for sure, but just on that premise itself, I'm going to say that nothing further is going to go out to the public. This isn't, it's not meant to harm any business by any means. It's unfortunately just the reality that we live in this day. In talking in the last 2-3 months, I've gone to a lot of different cybersecurity conferences, meetings, and so forth. And, we've said it for quite some time now. It's not a matter of have you been affected by this, but it's when. And that's the unfortunate reality that we live in. Everybody's targeted, and depending on what type of information you keep, you may be more heavily targeted. I feel right now your healthcare entities are ones that are being targeted very heavily just because of the information that they hold. So their systems, they're always trying to keep those up to date constantly and working towards that cybersecurity.
Right. I got a couple of questions regarding the law, kind of more back to that. The first one, I'm not sure that there's an answer yet because the law goes into effect on July 1st, but what is the actual number of the statute, or where is it going to be located? I know it's in 22-40, but what is the actual statute?
That I don't have yet. They should be coming out. I can find out and we can try and put something out there. It will reside in 22-40. I can't tell you anything further than that because I don't have the new books yet.
Right. But we'll know in a couple of days.
Yes.
So as far as the 250 or more people go, just a clarification on that. If 250 or more people are affected, is that when you have to notify the Attorney General's office?
Correct. If you deem that more than 250 people have been affected by the breach itself, then a notification needs to come to the Attorney General's office. If it's less than 250 individuals that are affected, notification still has to go out to those less than 250 people. But no notification needs to come to the Attorney General's office. You can voluntarily do. Go ahead.
Go ahead, I'm sorry.
If you can voluntarily, make that notification to us, I will tell you that a lot of consumers, they're getting better by questioning things. So if a notice was to come to them, they may call our office and ask whether or not this is true, what do they need to do. Then we walk those consumers through those steps. So it may, it's strictly up to, it's not part of the statute. You can certainly voluntarily call and let us know that a notice is going out, or you can send us a copy of the notice just so that we're made aware of it, so that when those consumers call in, we can say, yes, is this the letter that you received? Yes, we received a copy of that. This is truly what's happened. Here's the next steps that you may want to consider taking.
And that is for a breach of data of the personal or protected information, not just the scenario from before with the first and last name.
Correct.
Okay. So if a company determines, okay, we've had a breach, how long do they have to send the notice to the Attorney General?
60 days. This was something that was vetted, or this actual data breach proposal was vetted many different times. South Dakota Retailers was part of it, South Dakota Banking, the medical providers were a part of it. There were other individuals or lobbyists that were a part of this, and they went back and forth. Initially, we had a 30-day notice, then we went to 45, and to stay consistent with, I believe, the HIPAA notifications are 60 days. That was what we landed on. So it is 60 days from the time that you notice the breach. You have 60 days in which to file that documentation to us.
Yeah, there was definitely a lot of people at the table during this session for this bill. What about federal level? So does the Attorney General or your office have to report something at the federal level so that there's statewide statistics available?
Not that I'm aware of, no.
Okay. What about as far as filling out these, or the letting people know of the breaches, or letting the Attorney General's office know? Are you guys going to have an online form that these potential breaches can be shared with you?
We could come up with something along that lines. Currently, if you use that consumer help at state.sd.us, that is our consumer helpline. You would be able to put in your company's information, and then you would be able to put your comments or the scenario that takes place, that your breach occurred on this particular day. So you could use it in that fashion. We can certainly try to come up with a drop-down box that indicates this is a data breach, and then there may be other specific information that needs to be in there. So we're talking about that just to make it a little bit easier and quicker for businesses. So that is something that we are discussing, but that is currently an option for them to use.
Okay, perfect. I got just a couple of more questions here, unless they roll in the next couple of minutes. What about any exemptions? Do we have any exemptions, or does this law place any exemptions that would pertain to the size of a business, number of employees, annual income, or is it every business regardless of their size?
At this time, as the statute stands, it's any business, any size that is keeping that personal identifying information. There may be some things that, get looked at during the new legislative session that tweak it a little bit. But currently, the way it stands, there are no exemptions that I've seen in here.
Okay. So my last question is, how can we then, as a business, implement this or make it known to our staff members so they can start realizing the severity of protecting data?
Okay, and while not giving any legal advice or advice in that manner, some of the things, again, going back to some of the cybersecurity meetings and conferences and so forth, the one thing that they're the ones that dabble heavily into this, they see what's going on. The one thing that they stress is, one, to get a policy and procedure in place so that it's notated, people know what the responsibilities are, and updated as it's needed. If you don't have somebody on board with that, we're also looking at trying to put together, for those smaller businesses that just don't know where to go, putting together a list of potential businesses that are looking at cybersecurity, checking those systems. I know that one of the other things that they talk about doing is having somebody come out and check the vulnerability of their systems. And I think, Katie, if I remember correctly, and doing the meetings across the state with you guys have something that your retailers can use that comes out and does a vulnerability check. The other thing that's been mentioned as far as implementation is check your insurance policies. See what a cybersecurity breach, if that's covered in any of your insurance policies. I know that that is something that is starting to be implemented where companies can purchase that insurance. If you're looking at that, make sure you fully understand what you're getting, what your rights and responsibilities are, and what their responsibilities are as part of that policy itself. Just make sure that you fully understand it. But again, the one thing that I guess I stress as far as trying to get this through to your employees is get that policy and procedure in place. That was one thing that was first and foremost with any of the cybersecurity people that I've ever talked with is that policy needs to be put into place.
Yeah, perfect. And I guess I'd touch on our endorsed service provider, Infotech Solutions out of Madison, is available for our members to take a look at as far as keeping their data safe. And they will provide a risk assessment for free. If you're interested, you can just give our office a call. In April, actually, Infotech did a webinar for us on data security and safeguarding your business. Later today, we will email out to all the registered participants a link to today's recording, and then we'll also include a recording of that webinar. It can also be found on our website, and it has been in email updates that our members get. So with that, I don't see any other questions that have been rolling in. So I would just like to thank you again for today's presentation. Unless do you have any closing remarks you want to add in?
The one thing that I did forget to mention to you guys, and I go back to page or slide 6 of the presentation that you guys received. There is in the presentation that you received, there is an error on slide 6 where it talks about, yes, my information was taken, what my next steps are. It talks about within 60 days from the notice of the breach, disclosure of the breach must be made to any South Dakota resident affected. That South Dakota resident should be stricken from there. It's basically any affected person. We get going and talking about South Dakota residents, and unfortunately it just got in there. So that needs to be stricken. It's any affected person. And with that, if they've got questions, by all means, call our toll-free number. They can also send us questions through that helpline, and we'll try to get those answers sent back to them.
Okay, perfect. Well, thank you again for the presentation today. And just a few things before we conclude. As I stated before, this webinar was recorded, so we will be sending out a link to that recording along with the April 25th webinar on data security later today. A couple more webinars we have scheduled. On August 1st, we'll partner with the South Dakota Department of Labor and Regulation to present a webinar on youth in the workforce, including how to find new skilled workers, recruitment and management strategies, and job shadowing. And then on September 18th, we will be teaming up with the U.S. Bureau of Labor Statistics to show you how to use statistics on the BLS website to make decisions for your business. So you can check out those webinars and everything else at our website at www.sdra.org. And we'll also include a registration link with our recording email that's going out later today. I want to thank Jody again and thank everyone for participating in today's program.